Hello students, welcome to Epitome IAS. In this video, in this session, we are going to discuss about one of the mains questions in the UPSC examination. Right? The question is related to tribunals versus ordinary courts. So this is one of the very important dimensions because it is a recurring theme in the examination. Every time you would expect these kind of questions. Okay, so let us understand how to write answer for this particular question. Okay, let us read the question first. Okay, how far you agree with the view that the tribunals curtail the jurisdiction of ordinary courts, and in the view of the above, discuss the constitutional validity and the competency of the tribunals in the country. Okay, he is talking about how the tribunals are curtailing the jurisdiction of the ordinary courts. Number two, what is the constitutional validity and competency of the tribunals in India? So we need to understand these two. Here, of course, there are three dimensions to be addressed in the answer. Okay, it is of course 15 marker question. So we need to write something in the elaborative manner, right? So first of all, let us understand basically what are the tribunals about. Okay, so what is the meaning of the tribunals, right? Okay, so tribunal means, first of all, it is a quasi judicial body. Okay, so generally tribunals are established under a given statute. A statute will be there. That statute will be explaining what is the jurisdiction of the tribunals, what is the competency of the tribunals. Okay, so their jurisdiction is confined to only particular subject matter. So the jurisdiction does not extend as much as the ordinary court's jurisdiction actually extends. So they will be having very limited scope to settle the disputes. And moreover, the tribunals establishment has become so routine matter in the day-to-day governance of the country. Particularly after the liberalization, privatization, globalization, the number of tribunals have been actually multiplied. They are being proliferated in their number. Why? Because the administrative decision making, or you can say governance of the country, became very much complex. It requires to respond to the dynamic needs of the national and international importance. So naturally, the tribunals are required to be solving such kind of problems which are having technical importance on one hand. On the other hand, they might be required to be disposed in very shortest span of time. So where the judiciary is not able to satisfy that particular requirement, that's the reason why we require to establish the tribunals. Right? So that's why tribunals are nothing but quasi-judicial bodies. Quasi-judicial body means what? The judicial body which is not actually the judicial body. Right? So the judicial body which will be performing the functions not according to the procedural laws. Those judicial bodies which perform the functions according to the substantive laws, that is what called as quasi-judicial body. Right? So there will be no procedural complexity on one hand. On the other hand, there will be presence of technical members in the tribunals. So naturally, they are very much aware of the subject matter where the dispute has to be resolved. So that is the key for the success of the tribunals in the country. Right. So first of all, we can write some differences between tribunals versus ordinary courts. Thereafter, we can write what can be the potential answer for this particular question. Okay. So for the benefit of the audience, I am trying to explain you what is ordinary court and what is the tribunal. So let us understand both of these two. Right? So ordinary court, generally it is a kind of constitutional body. Usually constitutional body. Okay, in the case of suppose Family Courts Act and certain legislation exceptions, there are certain exceptions. Otherwise, all these are constitutional bodies. Tribunals are statutory bodies. Okay, and the ordinary courts make use of both the substantive laws substantive laws and also procedural laws, both substantive laws and procedural laws, right? I think you know what is the meaning of substantive law. Substantive law means the law which is supposed to be the basis for the resolution of a dispute. The law which provides you relief in a particular dispute is called a substantive law. For example, Indian Contract Act, where the contractual matters are to be resolved using the Indian Contract Act. That is what called a substantive, which is having some purpose, which is having some objective. That is what called a substantive law. On the other hand, procedural law is something where you are going to resolve the dispute on the basis of the procedure mentioned under the given law. For example, CPC, CRPC, Indian Evidence Act. So this is how they will explain, they will provide the basis how the disputes can be resolved. On the other hand, tribunals will follow only substantive law because the statute they follow, but with respect to the procedural matters, they will enjoy the flexibility, which procedure they need to adapt. So that is their flexibility. So that is why it is called as, it means they do not follow procedural laws. Procedural laws are not actually followed, but they have some expectation. What is that? They shall not be violating principles of the natural justice. They shall not be violating principles of natural justice. Otherwise, they can have the procedural flexibility. This is what the key for the success of the tribunals in the country. So this is the key for the adoption of the tribunals. Okay, they are able to help the resolution of the dispute without having procedural complexity. And moreover, this is what advocate centric, ordinary courts are advocate centric. Okay, whereas the tribunals are client centric. Okay, where you do not require advocate also, you can directly represent your matter, right? So with respect to constitutional bodies, that is ordinary courts, we can see presence of legal members or judicial officers, presence of judicial officers. Here there is no requirement of particularly the judicial officers alone. There will be, of course, technical members plus, right, there will also be legal members like senior advocates and other members. Okay, so they will be there, right. Next important thing is the ordinary courts deal with both civil and criminal matters, criminal disputes. Okay, whereas the tribunals usually, of course, if you have to establish the tribunals for the martial courts like that, that's okay, some exceptions, but usually the tribunals will be dealing with the civil matters only, and particularly those matters mentioned under the statute of parliament. Those matters mentioned under the statute of parliament. Okay, so except that there will be no other scenario where the tribunals will be dealing such matters. Okay, right. This is how we can resolve understand the matter. Okay, so usually the ordinary courts will find a more delayed justice. Here, very quicker justice. Comparatively, it is very much quicker, right? So but you understand the justice quality, the quality of justice tend to be high in the ordinary courts, and the quality of justice tend to be little moderate compared to the ordinary courts. Why? Because they are very much trained persons in the justice dispensation. Okay, so this is how we can understand. Okay, so now let us see what is a question that we have come across here. The question here is, how far do you agree that with the view that the tribunals have curtailed the jurisdiction of the ordinary courts? So we need to write what are tribunals. Okay, first of all, tribunals means in the introduction, tribunals means these are quasi-judicial bodies. In the introduction, we need to write these points. Okay, tribunals are quasi-judicial bodies. They are established by a given statute. Okay, statute is the basis for the establishment of the tribunals. Okay, and they will have to resolve the disputes as far as the jurisdiction permitted by the statute. Okay, they cannot go beyond that particular jurisdiction that is kept under the given statute. So that is how we can understand. Okay, so tribunals are nothing but quasi judicial bodies. These are established under a statute whose jurisdiction is limited by the statute itself, and which are established in order to resolve the disputes in the quicker manner, and particularly those matters which require technical expertise. So that is how we can write the introduction. And coming to the next dimension of the question, what is it, right? So whether they violate the or they curtail the jurisdiction of ordinary courts. Okay, we need to write this matter. Okay, so as far as this jurisdiction of the, so let us write what is the jurisdiction of tribunals. Jurisdiction. Okay, question is whether they curtail the jurisdiction of ordinary courts. Okay, right. So we need to write here. So just now we have differentiated, right? Ordinary courts usually have jurisdiction pertaining to civil and criminal matters. Okay, civil matters like property disputes, divorce, okay, contract, adoption, tax, or we can say those kind of matters. Okay, transfer of property. So we can find different types of civil disputes. Okay, and criminal matters means those matters which involve crime. Okay, and those matters which involve punishment, like kind of things. So ordinary courts will be having the jurisdiction in these areas. Okay, and so ordinary courts have larger jurisdiction compared to tribunals. They will not be having limited jurisdiction as like the tribunals. They will be having very larger and wider, we can say, wider jurisdiction. Okay, and right, and moreover, the ordinary courts will be able to entertain any case unless something is limited by a statute. It is able to entertain any case which is something limited by the statute. Suppose you take for example service matters. Okay, so that has been limited by Administrative Tribunals Act. Otherwise those matters can also be entertained by the ordinary courts. So like that. Okay, right. So coming to the tribunals, their jurisdiction, right? Tribunals, their jurisdiction is defined by statute. Required to perform as much as the jurisdiction permitted by the statute. Not beyond that particular statute. Okay, right. So that's why the ordinary courts to some extent, of course, traditionally dispute resolution functions are vested with the ordinary courts only. Okay, except in France and other countries, traditionally ordinary courts are required to perform the dispute resolution functions. But in the light of the liberalization, privatization and globalization, particularly, of course, the 42nd Constitution Amendment Act of 1976 has brought the tribunal system into the constitutional fold. Okay, before that also tribunals were there, but particularly the constitutionality has been imparted by 42nd Constitutional Amendment Act, where Article 323 A and B has been added to the Constitution, and particularly Part 14A. Part 14A has been added. Under this, these articles have been added. Okay, so the purpose, of course, the very expansion of this number of the tribunals has been increased after liberalization, privatization, and globalization, right? Because LPG has demanded the very faster state. It means more agile state. Agility means the state which is able to respond to the problems of the people, and the state which is able to facilitate the market. Okay, so that kind of state has been demanded after LPG. So because of that reason, the executive and legislature have taken much interest in the constitution of these tribunals. Why? Because traditionally judiciary has been overburdened by the cases. Okay, so that's the reason why some portion of some areas where the ordinary courts cannot resolve the disputes which are highly technical in nature, such matters are vested with the tribunals. For example, you take water tribunals, right? Water disputes. So these matters cannot be resolved by ordinary courts. This requires considerable level of technical prowess. So that's why what is established, for example, water disputes tribunals by means of Interstate Water Disputes Act, okay, under Article 262 of the Constitution, okay. And moreover, administrative tribunals, we can see the tribunals with respect to various other things like STAT, of course, CAT, State Administrative Tribunal and Central Administrative Tribunal. We can also see Speaker. Okay, Speaker is also tribunal under Anti-Defection Act. Okay, Attorney General is a tribunal, AG. Okay, with respect to contempt of the court. Okay. Sorry. Okay. Like that, there are various matters in which the tribunals are available. Okay. So that's why, of course, to some extent we can agree that the tribunals curtail the jurisdiction of the ordinary courts. Okay. In the sense that all the technical disputes are actually transferred to the tribunal system itself. Okay. So this is leading to a concern called as tribunalization of justice. Tribunalization of justice. Tribunalization of justice means more and more matters are falling under the scope of the tribunals to be decided. Okay. So the labor tribunals, and there are too many number of tribunals which are very much expanding into various new areas. So this is what called as tribunalization of justice. So what is the problem when this tribunalization of justice happens? What is the problem when the tribunals number increases? So the problem is that particularly the executive's involvement, the executive's influence over the justice dispensation increases. Okay, because tribunals administratively they are operated under the scope of the executive itself. Functionally they are, of course, they can be monitored by the judiciary, but however administratively, resources wise and personnel wise and even the day-to-day expenses wise, everything is done, everything is funded and controlled by the government itself. So naturally this poses a threat to principle of separation of powers, right? Because executive branch is involved more into the dispute resolution functions in the name of the tribunals. So this is what the concern. Okay, and moreover there is a chance that there could be a scope for conflict of interest. Conflict of interest means here the executive functions and judicial functions may be conflicting, because according to the principles of natural justice, no man is a judge of his own case. But however, the executive, who is the primary culprit regarding the some kind of dispute or something like that, so the executive may safeguard its own interest in the name of the tribunals. So there must be some independent judiciary to resolve the disputes. But however, due to the establishment of the tribunals, most of the matters will be able to be decided by the tribunals alone. Only few matters that can be challenged in the higher judiciary. Okay, so people may not be that routinely going to the higher judiciary in all the cases. So that's how that the quality of the justice may be compromised by this particular tribunal system. So I hope you understood the demand of the question. Okay. So now, so we agreed partially with this view. Okay. And in the view of the above, discuss the constitutional validity and competency of the tribunals in the country. So constitutional validity, are they really constitutional or not? Okay. Right, they are constitutional. Why they are constitutional? Because Article 323A and 323B. Article 323A talks about the tribunals regarding the administrative matters, and Article 323B talks about the tribunals related to other matters. Other matters means taxes, taxation, labor, revenue, international trade. So such kind of matters, in those matters, the both parliament as well as state legislature can establish the tribunals by means of a statute. So those matters which fall under the union competency, the union parliament can bring a law, and those matters which fall under the state level competency, the state legislature can bring the law. Right. With respect to Article 323A, administrative tribunals can be established. Right, that those administrative tribunals can be established only by means of parliamentary legislation, not by the state legislation. States do not have the right to, they do not have the power to establish the administrative tribunals. This is how two types of tribunals can be established. Okay, this is one aspect. So this is how they are constitutional. Okay, right. And apart from that, they are also constitutional because of the Supreme Court's justification. Supreme Court has actually validated the tribunal system in the country. Particularly if you try to look at Chandrakumar versus Union of India. In this case, Supreme Court said tribunals are valid, but however the tribunals must be subjected to the judicial review or judicial control, particularly by the high courts. So generally the law says the tribunals awards or the final, what is that, conclusions, we can say decisions, we cannot say judgments. For the tribunals we cannot say judgments. The awards or final decisions of the tribunals can be challenged in the Supreme Court. It said in certain matters the high court status as well as tribunal status is equated. So those matters will be requiring to be challenged in the Supreme Court directly. But Supreme Court said in Chandrakumar case, the tribunal's final awards shall be challenged in the High Court itself. That too with respect to divisional bench. In front of the divisional bench, those awards can be challenged. And further, it also upheld the tribunal system in the country. Okay, but it has argued for more judicial control over the tribunals rather than administrative control. That is one aspect. And coming to another aspect is Supreme Court in Madras Bar Association case. Okay, it held that Madras Bar Association versus Union of India. It held that the tribunals must be freed from the administrative control. They must be kept under some independent authority established by the parliamentary legislation. Till that point of time, the tribunal's administrative control must be kept under the law ministry, not under the administrative ministry which is party to the dispute. For example, income tax department, income tax appellate tribunal. So that appellate tribunal falls under the income tax department itself, and officials are members of the tribunal. So that is why it is having some compromise on the quality of justice or independent character of the dispute resolution bodies. So that is how Supreme Court has validated it. At the same time, it also has directed the government to bring these tribunals under the independent system. So this is the way we can think about this answer. Okay, so we have discussed both of these two dimensions. One is, and of course, constitutional validity and competency we have discussed when we discussed about the differences between the ordinary courts and tribunals. So this is what the rest of the answer here. Okay, in the second part, so this is what the table we have drawn here, we have written here, right? So this is the table. So we need to write this table here in the second part of the answer when we are talking about the competency. Okay, right? So this is what the whole idea about the question. Okay, right? So finally we need to conclude the answer. Okay, so we need to write, yes, the tribunals, yes, however they are very much important in the dispute resolution in the quicker manner, and despite offering the technical expertise, they are having some overlapping or some kind of curtailment of the jurisdiction of the ordinary courts. So more and more tribunals are established, naturally more and more shrinkage that happens with respect to the jurisdiction of the ordinary courts. Okay, right. And however, they are constitutional and they are also upheld by the Supreme Court in various judgments. Okay, despite that fact, the Supreme Court agreed that the tribunals are having some compromise on the independent character of the judiciary, and at the same time they are trying to curtail the jurisdiction of the judiciary in the country. In that context, Supreme Court advised that, in particularly in the Madras Bar Association case, that the tribunals must be freed from executive interference, both in terms of appointment and both in terms of their administrative control. Supreme Court also has advised the security of tenure must be provided, and they must be having a long tenure to be brought, and apart from that they must be having both judicial members and administrative members. Suppose if a matter is generally in importance, there is no requirement of more number of technical members, it may require more number of judicial members. So this kind of suggestions we can give in the way forward. We can write this kind of way forward in the conclusion. Hope you understood the full understanding of the complete understanding of this particular question. Okay, for more questions please watch Epitome IAS. Thank you.